the opinion of jurist is sharply divided concern the status of international. Status of international law here implies whether international law is a law in true sense or not. There are two views in this regard. According to the first view, international law is not a true law. According to this view, or the supporters of this view, international law is not a true law. Then according to them, what international law is? According to them, international law is code of conduct. According to them, international law is a code of conduct that is being followed by the countries. On what ground it is being followed? It is being followed on the ground that it is morally right, or we can say having moral force. Complete. Now we'll see who were the supporter of this. This view was supported by Austin, Holland, Bentham, and Hobbes. The other view was international law is a true law. International law is a true law. This view was given by this jurists such as Stark, Professor H.L.A. Hart, and Oppenheimer. According to them, international law is to be regarded like any other, law in the principle, like any other principle. Now, the whole controversy whether international law is a law or not is only of academic relevance. It has been settled for once and all that international law is a law. But still, discussion of this topic or issue that whether international law is a law or not is important, and it helps us to understand the nature of international. The view that international law is not a law was given by the jurists who were trained and groomed under municipal law and jurisprudence. They were seeking the element of municipal law in international law, which were not present there. That is why they were of the opinion that international law is not a law. They were under the fallacy that there could not be any other system of law and jurisprudence except municipal law. They failed to take into consideration that both systems of law operate in completely different environment, where municipal law operating centralized system and international law operating decentralized system. This whole debate whether international law is a law or not is only because of the definition of a term law. Given by various jurists. If they find the characteristics of their definition of term law were present in international law, then according to them, international law was a law. If they do not find the characteristics, if they do not find the characteristics of their definition in international law, then according to them, international law is not a law. In this regard, we will discuss the view of Austin, who was of the view that international law is not a law. According to Austin, law is a command of sovereign backed by sanction in case command is not known. In the definition of Austin, there are two important elements. First, law is command of the definition implies punishment. In case the command is not obeyed, there were adequate punishment. So Austin applied his definition of law on international law and came to the conclusion that international law is not a proper law because there was no sovereign authority to make law and it lacked adequate sanctions. The view that of Austin that international law is not a law was criticized by many jurists. One of them was Professor H.L.A. Hart. He was of the view that international law is a law because states regard it as a law. Coming further, we will discuss the views of Oppenheim in this context, who was of the view that international law is a law. How he came up with the conclusion that international law is a law? He must have applied the characteristics of international law in his definition of law. Then only he would have come to the conclusion that international law is a law. According to Oppenheim, law is a body of rules for human conduct in a community, which with the common consent of community are enforced by external forces. In the definition of Oppenheim, the important element is common consent. And according to him, common consent of nation is the basis of international. Oppenheim says international law, or we can say Oppenheim gave two reasons in favor of international law as a law. First one was the states were obeying international law. The government of the states were obeying international law in their conduct or in their intercourse. Second, while breaking it, no state denies the existence of international law. They try to justify their action within the provisions of international law. Stark also came up with certain arguments in favor of international law, as he was also the supporter of the view that international law is a law. According to him, in primitive communities also, there were certain rules, though there was no sovereign. Second, international legislation in form of law-making treaties have came into existence. These were the views of Stark in favor of the view that international law is a law. Few countries like US and UK regard international law as their law of land, as said by Justice Gray in Packard Hamara case. So, though we can say international law is a law, but when we compare it to a municipal law, it is a weak law.